Just when we thought there wouldn't be any more filings until July, Quadajah Johnson's attorney just made another move. This time, she's not asking the Illinois Supreme Court to reconsider anything. She's asking the Illinois Supreme Court to speed up the clock so Quadajah Johnson can be released from custody ASAP. When people do the most, I do the analysis. Let's go. On June 24th, Quadajah Johnson's attorney filed what's called a motion for early issuance of mandate. And while it may sound like legal jargon, this filing could determine whether her release hearing happens weeks sooner than expected. Today we're going to break down exactly what this motion says, why it was filed, and what the chances are that it gets granted. I'll give you my prediction at the end. To remind you where we are in this case, the Illinois Supreme Court recently denied the state's petition for leave to appeal, also known as the PLA. That means the Supreme Court decided not to review the appellate court's decision, and that decision was to overturn Quadajah's detention order set by Judge Clancy in the lower court. A lot of people assumed that meant everything would immediately move back to the trial court, but not quite. After the Illinois Supreme Court issues an order, it doesn't immediately send the case back. Instead, it waits about 35 days before issuing what's called the mandate. Think of the mandate as the official paperwork that says, the Supreme Court is finished with this case. Judge Clancy, you now have jurisdiction over this case again. So according to this motion, the mandate isn't scheduled to issue until July 16, 2026. That's roughly 35 days after the Illinois Supreme Court decided they're not going to get involved with this case. Until then, Judge Clancy's court basically had his hands tied with respect to Quadajah Johnson's detention status. The defense is asking the Supreme Court to skip that waiting period. Ari Williams is essentially requesting that the Illinois Supreme Court issue the mandate immediately instead of waiting until July 16. And why is that? Well, because every day that passes is another day that Quadajah Johnson remains in jail. The motion points out that Quadajah has been detained inside the Cook County Jail since December 4th of 2025. Her defense argues that she's still presumed innocent and because the Illinois Supreme Court has already denied the state's appeal. There's no reason to continue delaying implementation of the appellate court's decision, and that decision is to release Quadajah Johnson from jail during pretrial. The defense also argues that continuing to detain her is causing hardships for her. Things like separation from her family, loss of employment and income, difficulty helping prepare for her defense, and suffering from the physical and psychological effects of incarceration. Their argument is quite simple. The only thing standing between Quadajah Johnson and her release hearing is paperwork. Let's talk about what the defense is asking for specifically, and this is where I think folks are going to misunderstand this filing. The defense is not asking the Illinois Supreme Court to release Quadajah Johnson. If this motion is granted, Quadajah does not automatically walk out of jail. Instead, the mandate is going to go back to the circuit court sooner. Then and only then can Judge Clancy finally hold the hearing that was ordered by the appellate court, a detention hearing. At that hearing, Judge Clancy will decide the condition of Quadajah Johnson's pretrial release. Again, that could include electronic monitoring, home confinement, or other conditions that the judge believes are appropriate. So this filing by Quadajah's attorney is about speeding up the process, not changing the outcome. It's very important to make that clear. I actually think the defense makes a fairly logical argument. Once the Illinois Supreme Court declined to hear the appeal, there really wasn't much left for them to decide. The defense also cites Supreme Court Rule 368A, which specifically allows the court to issue the mandate earlier than normal when appropriate. So legally, the Illinois Supreme Court has a rule that gives them discretion. Now, whether the court chooses to exercise that discretion, that's another question. Courts generally like following their normal procedures unless there's a compelling reason not to, so the defense does have a reasonable argument. But that doesn't necessarily mean they'll win. We'll just have to wait and see. Now, I promised to give y'all my prediction, but before I do that, there's something else happening behind the scenes that I think is worth paying attention to. Earlier this month on June 8th, the Illinois Supreme Court announced the creation of a brand new Pretrial Accountability Task Force. Now, I'm not saying this task force is deciding Quadajah Johnson's case because they've already ruled on the state's PLA and there's nothing more for the Illinois Supreme Court to do with Quadajah Johnson's case. But I do think the timing is interesting. Let me tell you why. Just days after creating a statewide task force to study electronic monitoring and pretrial accountability, the Illinois Supreme Court declined to review the state's appeal in the Quadajah Johnson case. Now, we can't say for sure that one caused the other, but it is possible that the court believed these broader policy questions would be better addressed through a comprehensive statewide review rather than through a simple criminal appeal. This task force was created to examine how Illinois' pretrial release system is actually working across the state and how it's not. The task force is expected to look at issues involving pretrial detention, electronic monitoring, court supervision, public safety, victim concerns, and whether the current system is achieving the goals that lawmakers intended. And if you've been following the Quadajah Johnson case with me, you know this case has raised many of those same questions. Questions like, how should judges decide who remains detained before a trial? What does dangerousness really mean under Illinois law? And how much weight should courts give the facts of the alleged offense versus a defendant's current risk to the community? And how should appellate courts review those decisions? Those aren't just questions in Quadajah Johnson's case. They're questions that courts across the entire state of Illinois are wrestling with. So while this motion from Quadajah Johnson's defense is about one defendant asking for the mandate to be issued sooner, it also arrives at a time when the Illinois Supreme Court is stepping back and taking a statewide look at how pretrial release is functioning as a whole. And that's why my next video is going to take a deep dive into this new task force. I'll let you guys know who's serving on it, why they created it, what it's supposed to accomplish, and whether it could shape the future of pretrial justice in Illinois. Trust me, you're going to want to watch that one. Because if this task force recommends changes to the Illinois pretrial system, those recommendations could eventually affect cases just like Quadajah Johnson's and possibly thousands of others across the state of Illinois. If you think this case has been interesting, just wait till you see the bigger picture. Here's what I think about this motion, though. I actually believe the defense's motion has a decent chance of being granted. I do. Not because the defense just found some brilliant legal argument, but because there's really not much left for the Supreme Court to do. I mean, they already denied the state's PLA. Granting this motion wouldn't change any legal rulings at all. It would simply allow the appellate court's decision to take effect a few weeks earlier, 3 weeks to be exact. Now, would I be shocked if the court denied it? I wouldn't, because courts tend to stick to their standard timeline simply because those are procedures that exist for a reason. So if I had to put a percentage on it, I'd probably say about a 60% chance that the motion gets granted and a 40% chance the courts let the mandate issue on July 16 as they originally scheduled. Either way, I don't think this changes the ultimate direction of the case. So the only real question right now is when Judge Clancy gets jurisdiction back, not whether he'll get it back. And in the meantime, Quadajah Johnson and her legal team can just hurry up and wait. If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. Do you think the Illinois Supreme Court should grant the defense's motion and speed up the mandate, or should they tell Attorney Ari, "You're not the boss of me"? Meet me in the comments. We can continue the conversation there.